Hello, everyone, and welcome to Stress Free IEP, the show where we help families build their village so they can raise their neurodivergent children with confidence, clarity, and support. I'm your host, Frances Schefter, special education attorney, advocate, and fellow parent walking this journey with you. Whether you're joining us live on Facebook or YouTube or listening later on your favorite podcast app, we're so glad you're here. Let's dive in and meet today's amazing guest. Lisa Zeiderman is managing partner at Miller Zeiderman LLP, which is a law firm based in New York. She's a matrimonial attorney, CFL, and certified divorce financial analyst. She regularly handles litigation and complex financial and custody divorce matters, as well as pre and post nuptial. I am stumbling today. Pre and post nuptial agreements. Lisa, welcome to the show.
Thanks so much, Frances, for having me.
I'm so glad to have you here. So I know people are like, divorce attorney. What are you having a divorce attorney in New York on an education show? But it matters, right? Like this is things you need to consider, even like going to the pre-nuptial and post-nuptial, even if you're not even considering divorce. These are things you need to think about.
For people who have children with special needs, neurodivergent children, many times divorce becomes part of their lives too. And we see huge disagreements sometimes about treatment and testing, and the idea of putting your children into special classes or having them go to certain specialists and all of that. So I think that it is very appropriate to have this conversation because in my practice, we see so many arguments, frankly, and disputes over these issues. And sometimes it's not even known that a child is neurodivergent when they first start a divorce, when the parents first start a divorce. And it could be that there were disagreements before about various issues. But then as they're going through a divorce, there might be certain psychological testing of the family in general. And some of these things may come to light. Or it could be that a child goes through a specific diagnosis during the divorce case. And all of a sudden, everybody who is maybe having disputes over smaller things or larger things, this becomes a very big dispute, and it is actually relevant to custody matters.
Yeah. No, and I see it a lot. I mean, I've actually been hired by one parent, and either the other parent has an advocate or an attorney or it doesn't. I also do represent some families that are divorced, but thankfully the parents are on the same page. But I always have to explain to them, if you guys stop being on the same page, I'm going to have to exit. Like, we can't represent you anymore. Thankfully, although, so you can tell they're divorced sometimes, but they're on the same page of what they want for the child. And I know I've seen it, separate families because it's not an easy thing and it's stressful. And if you're adding to that stress, the stress of your spouse and you disagreeing, then it's just, it makes marriage even that much harder.
Yes, it does. There's no question about it. So I think that it is definitely issues that we deal with every day with our clients.
Yeah. And it's, I think about like the prenuptial, for those that don't know, is agreement before you get married, and the post-nuptial is the agreement after you get married. And it's important, I know when I did family law many, many moons ago that I hated, it was, somebody, people would be like, I don't want to do that. That, like, how are you planning for divorce? And I'm like, you're not. You're actually having a discussion of some pretty important things that matter in the marriage. I've seen people doing a prenuptial agreement, and when they start getting into the weeds of it, realize that they are probably not the good idea for them to get married because there's too many differences on big parts, and sometimes love isn't enough.
I think that's true. Look, we are doing more and more prenuptial agreements. I'm of the mind lately that prenuptial agreements should be required nationwide. And I'm of that mind because I do think that it's almost as if there is a reckoning of what's important to everybody as they are negotiating their prenuptial agreements. And had they not had that conversation, they would be going in very blind a lot of the time, not all the time, because nothing is all the time, but blind in a lot of ways, blind to the finances, blind beyond the finances, frankly, to areas of what's important, what the values are for each party, what do they value most. So, for example, and this is again, I think, relevant to what your show is about. Um, if we have a parent and we have a stay-at-home parent, is that something that both people are going to support? And does one party want to be a stay-at-home parent, or does one party object to the concept overall that there is a stay-at-home parent? And have we considered the fact that maybe we will have children with special needs of some sort, and we might need a stay-at-home parent? And here is, I think, the key, right? So for a prenup, okay, we can't actually talk about what's going to happen in terms of support and custody. But in a postnuptial agreement in New York, if a child is already born at the marriage, we can talk about that. And we can actually make arrangements that if there is a stay-at-home parent who is taking care of, for example, a special needs child or otherwise, right, who's just a stay-at-home parent taking care of children that are not even special needs, will that parent in some way be able to be compensated for being out of the career space for a very long time or even a short time? You know, we see that trajectory of people being able to earn and earn and earn, right? Their earnings go up, but the stay-at-home parent who comes out maybe 10 years later from being a stay-at-home parent, right? 2 kids or 3 kids, and now like I've decided to go back to work, or I've been out of the workforce for 15 years or 20 years, and now I'm in my late 50s, and we see more and more of that as there is more gray divorce, meaning people who in their 50s and 60s who are getting divorced. That person who had been staying at home, yes, they still might get 50% of the assets. So, you know, in New York, it's equitable distribution. There's no guarantee of 50%, but if it's a long marriage and there's not an extraordinary reason, I think for the most part, it's going to be 50-50 of the assets. But you know, your spouse may be earning incredible income after all these years, and you've been out of the workforce, and here you are now basically trying to get back into that workforce. Well, you're not getting back on that same level as your spouse who has been going, you know, tier after tier after tier and working their way up. You're coming in down here, and I'm sorry, in your 50s or your 60s, you're not going like that, okay? Unless you are like a super person, okay? And
And
so,
even like even if you were here when you left the workforce, you're starting back here again because
yes,
you're not, like there's been too much going on.
yes. And so I think that there are ways to deal with that issue, both in prenuptial and postnuptial agreements. And if you are, particularly if you have a child who does have special needs, and and you both have decided, or one of you has decided that it's best for a parent to be home as opposed to a caretaker, or as opposed to putting the child in daycare, or as opposed to a million other choices, right? But that you really want to be hands on for that child, then the thing to have done is to be negotiating that post-nuptial agreement if you don't have the prenuptial agreement, and making sure that you are going to end up in a situation where you are still sharing the wealth and sharing the opportunities that your other spouse had while you've been supporting the family and their career.
Right. Yeah, and I mean, the other thing to look at is I don't know if it's happening in New York, but here in Montgomery County especially, there's more and more families that are choosing to homeschool because, yeah, the schools have gotten as good as they are in the States, there's a lot of challenges and they don't meet everyone's needs. They do the best they can, but it's a challenge. And so if one parent gives up their career to be home and homeschool the child, what is that going to look like? Because, like, yes, they're giving up their career, but it's saving how much money in private school that could have been paid.
I think that's an excellent point. We don't see it very much. I'm going to say that. We see it sometimes. And I think that it has to be something that both parents are really on board for. Um, and sometimes, unfortunately, during divorce, we see that there's now again a split on that. Maybe it was okay when there was an intact family, but not so much when there's not, because the problem, of course, with homeschooling is that the parent, um, let's just say that there's a 50-50 custody arrangement. Well, now the child is going to the other parent, more than half the time, right? Because they're going to be homeschooled by that parent. And maybe they weren't so on board, but they went along with it when they were in an intact family. And so I think these are all great things to be putting down in postnuptial agreements once the child is born. And also certainly things that should be thought about. If this is something that is important to you, then it's important to have these discussions even before you get married.
But 100%. And even after. I mean, it's things I can see, or I have seen also, how it tears families apart and how one family will go and, you know, the judge what I hate when parents are divorced and nobody has decision making and the parents disagree. And so, like, you gotta go to court, because the school's not getting involved. And I don't know, like, is the school going to listen to one, or the school's probably going to listen to the parent? That, like, what happens? I don't know what happens in New York,
Well, what
but
happens is if you have, I mean, I do not write agreements where there's no decision maker. I'm going to say
yeah,
that. Okay. Either both parents are going to decide jointly, and if they can't decide, then they may use what we call a professional model, which is they go to see the professional that's relevant to the issue that they're disagreeing about. And the person who is most aligned with that professional will make the final decision based upon that professional's recommendation. That's a solution. And if they disagree further, there could be something that a mechanism whereby they use a parent coordinator to flesh out the issue, and then the parent coordinator can make the recommendation, which is very clear usually, and the parent who's more closely aligned with the parent coordinator on the issue. In other words, more that parent coordinator has looked at the two positions and said, okay, I agree with parent A. And so parent A will make the final decision, subject to everybody always having the right to go to court and ask a judge, if they don't agree, to look at it, what is in the best interest of the children. Now, I'm going to say, if you have a professional and you have a parent coordinator, usually, right, the judge is going to probably continue what is in place, unless there's an extraordinary situation where it's just not in the child's best interest. Something has gone wrong here, right? And decisions are being made that just don't make any sense. The judges really can't decide, for example, whether your child should be going to school A or school B, or whether the child should be seeing psychiatrist A or psychiatrist B, or whether the child should get an IEP, or any of those things. What the judge can decide is which parent should make the decision.
right,
And so that's really because the judge can't actually make decisions for the child, right? They don't have the opportunity to be speaking to the professionals and all of those things. So they're going to figure out which parent has the best capacity and is in the best position to make that decision. And also, as part of that decision making, whether the parent, usually the parent who is going to be chosen, is going to be the parent most likely to take the other parent's opinions into consideration.
right. Yeah, and I mean, it's definitely a challenge because there are so many options and so many things and so many disbeliefs of like, I've heard parents like, "My child's not special ed," and I'm like, "Your child is in 5th grade reading on kindergarten level. What do you think this is?" You know what I mean? Like, that are clear, issues, and I get it. As a parent, you don't want to, and I hate using these terms, but like think your child is damaged. But that's some people's mentality of a child with special needs. And it's like, child's not damaged, it just has different needs. And let's get them the needs and supports they need, that will help them get to where they need to be. And if you have that difference of opinion, it's really challenging. And even, going in front of a judge, the judge doesn't always understand everything. And so to teach the judge, as attorneys, to teach the judge of like why what this parent is making the decision, why it's the better choice than what this parent wants, and why this parent should be making the decision, that can be challenging as well.
Without a doubt. And I think that people need to consider the fact that coming together is easier, right? Better for
Yep.
the child. But many people can't come together. And
Yeah.
then the judge will make a decision as to which of the parents should be making the decision, usually, right? And that may be sole legal custody, because we have different areas, right? So you could have sole legal custody, you could have which means that the parent makes the decision, informs the other parent, may consult with the other parent, but basically that parent is in charge, period, of all major decisions. There could be zones of decision making where one parent makes medical decisions, another parent makes educational decisions, another, one of the parents makes extracurricular, the other parent makes camp.
Right.
Various ways to do it, right? If the parents can't get along, they're not going to, at the end of the day, have joint legal custody. It's not going to happen, because otherwise the court is just looking basically at a merry-go-round of people coming through.
Right. I was going to say monthly
Right,
court dates to
exactly.
make
Monthly court cases,
decisions.
and they just can't sustain that.
Yeah.
So it will, at some point, there will be a trial, and the judge will decide which of the parents is going to make which decisions, or which parent is going to make all the major decisions. And then, of course, there is the joint legal custody, where there is a whole consultation process, but there is a final decision by a parent. Another way to deal with this. And then there is the joint legal custody with a tiebreaker mechanism, which is what we discussed earlier. If there's a trial in New York, it usually means there's not going to be joint legal custody. It would be rare to see joint legal custody, not impossible, but pretty rare to see joint legal custody after a full trial, because that merry-go-round is not going to happen again. And
Yeah.
the judge has probably just lived through weeks and weeks of testimony and lots of exhibits, and has no more desire to be hearing this all over again in a year.
Right. Yeah. And that's why like doing the pre or even the post nuptial agreements makes sense, because you're doing it when you're getting along
Yes, although
before
keep
her.
in mind, if
Yeah.
there's no child born, there can be no custody provisions and no child support provisions. So it may be a prenup. It may be a post-nup, because you may have a child who's born after the marriage. If you have a child born before the marriage, you could do it in a prenup. But I will also say it will be subject to modification based upon the child's best interests at the time. So nothing will be written in stone forever in any custody agreement, by the way, at any
Yeah.
point, because children's needs change. And, particularly children with special needs, their needs change. They may have a preference for a particular parent at one point, and then a different preference later. And so it's always open to change.
And with child support, which people don't always understand, is that it's it I don't want to say it belongs to the child, but it does kind of. It's the benefit of the child. So a parent can't really say, no, we're not getting child support, because that's not the best interest of the child. And the judge isn't going to allow that.
Correct. I mean, there are some cases where people's income are so similar, uh, where they are sharing, equally of the child. And so there might be some lesser amount or minimal amount of child support, or some language about that, but they may be sharing what we call add-on expenses. And those are essentially the extra expenses that are major, such as private school, you mentioned, camp, therapy bills, unreimbursed medical bills, all of those things may be shared, extracurricular activities, um, medications, all of these very expensive items may be shared on some pro rata basis. But for the most part, usually child support is paid in one direction or the other.
Right. Yeah, and it's, like, again, like, things that you don't necessarily think about. I'm thinking, of course, I'm thinking of my husband and stuff. We have 2 neurodiverse kids, and thankfully, we're on the same page, but also the fact that I'm an education attorney, he kinda leaves that up to me, you know, like, um, but, like, I could see how it can get difficult. Like, we definitely don't always agree on parenting, but there are certain hard lines that he respects that I have, and I respect that he has, and that's, we don't have to always agree, as long as there are certain, that we respect each other and
Yes.
parents, and take that step back. I know at the beginning, just because of my background and my education stuff, I would interfere with his parenting sometimes, which undermined his ability to parent. And which was bad, because then the kids aren't going to respect him as much, because they're like, well, mom can overrule you. And usually his response is on some things, not on all things,
Good
but
for
like,
him.
right? But like, it's true, and he can overrule me on some things. Like, we have that. There are certain things that, like, yep, I defer to dad on that one, or he defers to me, and it's good. But like, I'm thinking about it, like, what happens down the road if something happens? Like, no, do we want to think about, like, down the road if divorce happens? No, but it could. I don't foresee it, but you never know. And so, sitting down and doing a postnuptial agreement of, like, we're going to keep it as is. This is, how we're going to do it. Dad's going to make decisions on this, mom's going to make decisions on this, and make it out there. I think, like, I'm laughing to myself, because I'm like thinking, like, in some ways it might prevent a divorce from later, because
That's
right?
the
What do you look
idea.
at
Okay.
things?
That is the idea of a postnuptial agreement. Is the idea of a postnuptial agreement is not to get divorced. The idea of a postnuptial agreement is to prevent divorce, to prevent marital strife, to make things much more transparent and clear, to make everybody feel more safe and secure, to solve and resolve the issues that are out there between a couple, so that they no longer have those issues, whether it be financial or children oriented or some other thing. It is a way to do that, and in many cases, people who have postnuptial agreements will remain married forever, and they will not be worried about their postnuptial agreement. It'll just sit in a drawer and never be used. But it is a very useful document.
Yeah, yeah. In Florida, when I did family law, we had the joke of, it's cheaper to keep her.
We have that in New York too. And I will say, I want to say one other thing about postnuptial agreements, which is that they are not valid in every state. So you need to look at your state rules. I am speaking as a New York lawyer, okay? And this is not advice for anyone. But I will say that everybody, right? I'm not giving legal advice, but everybody does need to look and speak to a trusted attorney in their area to see if a postnuptial agreement would be valid before they enter into it. Same thing with a prenuptial agreement. And they should definitely do that consultation and see if it's right for them.
So, here's a question that just popped in my mind. If you, like, say you live in New York and they do a postnuptial agreement with you, and then move to Florida, does that postnuptial agreement still stand?
Yes, likely is the answer. But okay, again, I would, before I make my move, I would absolutely consult with that Florida attorney. What the postnuptial agreement that we would write in New York would say is that no matter where you live, it will be interpreted and enforced under New York law. And
Uh,
in New York, it would be. And my view is that it should actually be upheld. But the way to know that for sure is to consult with the attorney in the area that you're going to.
right, because every state's a little wonkier, um,
Yes.
different. And it's people don't think about a lot of these things, when making determinations, when making decisions, having children, moving, this and that. And I met with some of my I had some high I have some high school students through the Summarize program. We were meeting with the judge, and the judge said, "Be the most prepared person in the room always," was one of his advice, which is good. And like I'm thinking about that as in this context, be prepared. Like I'd rather be prepared and not need it. It's just like why do we have insurance? Just in case, right?
Exactly. It's exactly why we have it. And by the way, what people also don't understand is that if they don't draft their own, right, they have one. They
Right.
all have one. You all have a prenuptial agreement when you get married. It's called the law, right,
Right.
of the state in which you are. So if you're married in New York and you're living in New York, then New York law is going to be your prenuptial agreement unless you craft your own. And if you got divorced, New York law, if you're in New York, would be your law, right? As long as you qualify for your jurisdiction. And if you have a postnup or a prenup, then you could have crafted your own, obviously within the framework of the law and as mandated by the law with the requirements, etc. But you could have crafted your own law, which is again why I go through this and I say to myself, why wouldn't people want to do this?
Right.
Why would they just want to take whatever New York law, for example, offers and just go with that? They
Right.
probably haven't read it.
Yep.
So they have no idea what they're signing up for, but minute they got married, they signed up for New York law.
Right.
If they
Yeah.
obviously got married in New York and intend to stay in New York and
Right.
all of those things.
And it's, people are like, oh, but it's expensive to hire a lawyer to do this. Trust me, it's more expensive to hire a lawyer, two lawyers in divorce,
Yes.
like pay up front. And that's, as attorneys, we joke around about that all the time is that clients try to save money and they do something wrong. They don't do, something that should have been, and they wind up paying attorneys twice as much to fix it.
Yes, that
And
is the
so,
problem.
like it's it's there for a reason. It's a tool for a reason. It's worth money. I mean, if not, if just a peace of mind of like knowing, like if something were to happen, what's next? It's the same thing like with doing our wills. Like, do we want to die tomorrow? No. Do we want to think about who's going to have custody of our children? No. But the reality of it is, do we want the judge to determine it because the families are fighting?
Exactly.
No.
Exactly.
Yeah. And nobody wins in litigation. Nobody wins.
That's right. That's right.
It's
And so it's really important to try to craft your own agreements.
Yeah, and where you can meet in the middle because yes, there are some hard lines, but even with the way the law is written in New York, there's still some gray. There's still some like, well, what do we give credit for? What do we not give credit for?
Yes,
Um, and whereas if you think about that and plan that all out ahead of time, it just makes life easier.
100%.
Yeah. And so what like I know there was something you said about like is there ever a time in New York? I don't think there is in Maryland, but is there ever a time in New York that the schools like I think you did. I think we did talk about that when professionals make the decision, but that's when New York has that mechanism.
Yes. So it's not that New York has the mechanism, it's that you can agree in your parenting agreement or your postnuptial agreement or your stipulation of settlement during a divorce that you're going to utilize what's called the professional model. So, professional model kind of looks like this. Parent A, send parent B my idea for resolving the issue. Our child, for example, might have dyslexia. Okay. And I want our child to go to a particular school or be enrolled in a particular program because I've heard that this is great for dyslexia. And parent B says, no, no, no. Okay. I do not want our children or our child going to that school because I don't want our child classified with dyslexia. Let's just say that. Okay. Common issue, right? And the um, learning, the educational consultant that the parents have worked with, or the guidance counselor or any of this protocol, the professionals that are involved with this child say this is a great school or a great program and your child would thrive in this program. And there is sufficient funds, or I'm going to get those funds from the school district or whatever it is, right? And parent B is like, no, 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 no way. And parent A is, this would be so good for our child. And the professional now, let's say it's the educational consultant that both parties had agreed upon in the event that there was a disagreement. The educational consultant says, I agree with parent A, and the child should go to this school. And parent A then, according to the agreement, has the right to make the decision in accordance with the recommendation of the professional, which would be the educational consultant. Parent A that then decides, I'm going to send the child to the school, informs parent B. Parent B is resistant, but understands that the child is going to that school because that's the agreement that they've signed. Or parent B absolutely is insistent this is not in the best interest of the child and takes it to court and says, Judge, you have to decide now whether or not this is in the best interest of the child. And the judge hears the testimony from parent A, parent B, the educational consultant,
Yep.
and arrives at the conclusion that likely parent A, okay, is in the right, looks at maybe exhibits about the testings, looks at a neuropsych, looks at all the information and says, okay, I'm going with parent A. Parent A has the decision making.
Yeah. Because it's, I just had a thought in it, as my husband would say, died of loneliness.
Oh, I love that.
Isn't that great? I love that one. But yeah, I mean, it's like thinking about it that there's so many, decisions and options and choices that, like even when parents are happily married, there's, conflict of what the child should be going through and what's best for the child. And, as we always say, parenting is hard enough. Right? Like just when we think we have it figured out, our kids go and shift something up again.
I know it's crazy, but it's really true. And I think parenting is very hard. Look, I think parenting is hard under all circumstances, but the additional stressors certainly make it harder. And with children with special needs, it's going to be harder. And if you're not on the same page, it certainly makes it more difficult.
Yeah. And that was it. So you had said that the
The board
parents,
game. Okay.
I know, right? The parents agreed on the advocate. So do you actually write in this is the educational consultant we're going to use?
So we don't always, but if there is a person already in place, then maybe we will, is the answer. If we could get everybody to agree that, I'll just use Sam has been the educational consultant forever and we love Sam. Well, then Sam is going to be the educational consultant. If Sam can't do it anymore, Sam may actually choose a next person to supersede Sam because everybody trusted Sam so much.
Got it. Because I can think of parent A found consultant A and parent B found consultant B. And guess what? They don't agree.
Yeah. So sometimes that's when you have the parent coordinator, who is the person who may decide, call up the A and the B and decide A is just so much more qualified. You guys are going to use A.
Got it. Yeah. Because I can see that because, even with when I meet with potential clients and what I do is I call it a strategy session. We talk through strategies of what is it that you want? There's always more than one avenue you can take. And what is I have clients that are dead set. They want their kid to stay in the homeschool period, in gen ed, in the homeschool. I don't care that the IEP is not being implemented correctly. I want them there. The kid is happy there, want them with friends. Let's figure out which way to go. I have other parents that are, and even though the child, there's enough argument there that we could go to a different program, but the parents don't want that. And then I have other parents that are I don't care what happens. This school is the worst. I want them out of the school. I don't care where they are, and it could be similar profiles of the kids, but what the parents want, neither are wrong. And I always say to potential clients, like, if you come into my office, or you're, as a potential client or as a client, and you're arguing hard that your child should be at a certain, non-public school, a special ed school, and I disagree, we're going to withdraw from representing you, because, yes, there are definitely possibilities, but I'm not going to advocate for what you want if I don't truly believe it's what your child needs,
That makes perfect sense.
right? Or that
Makes
there's
perfect sense.
data that you're to support it, because
Right,
you need the
exactly.
data.
And
So,
so that, that will be that would be the interesting thing, right? Is if you as the attorney, right? You're the educational attorney in that case, right? And if you are saying that it's not right for the child, and let's just say there was parent B who thought that it was right for the child, well, then it may be likely that parent A is going to make the decision at that point.
yeah,
And maybe parent A is going to go into court and say, nobody's agreeing with parent B, and this is these are the list of people we've consulted with, and this is what is going on. And the court may have to take testimony.
yeah. Yeah, which makes sense. And it's now, I know you're in New York, so you're just licensed in New York, for
Yes.
anybody, because I get this question often. For me, education law is the only law that has this. I'm licensed in DC, Florida, and Maryland, so I can be an attorney in those three states, but I can be an advocate nationwide, and including American schools overseas. And
Interesting.
so, right, it's because IDEA is written that you can bring a person of knowledge, and that's an advocate. So I always make it clear, like, yes, I can definitely consult with you. I can be an advocate. I can come with you. And people are always asking me, well, what's the difference? I'm like, I can't give you legal advice.
Right.
Like, well, but does that mean you don't tell me something? I'm like, no, it's just not legal advice. Like,
Right.
I can, here are your options. Here's what could happen. Here's what couldn't happen. It's just not legal advice. And they're, they get confused, but it works. Like, because I would say 75% of what I do, maybe even closer to 85%, is advocacy. But
Yes,
having,
for
yeah,
us too, right? For us
right.
too. But we just do it in New York. I'm licensed in Connecticut also, although I tend to practice in New York.
Got it. Yeah. And I mean, that's the thing. It's like advocacy, why it helps to have an advocate, because I get this question all the time, an advocate versus a lawyer, why it helps to have a lawyer is that we have the ethics that we have to file, and there's mechanisms if we screw up, whereas advocates don't. There's
Right.
also that we have to have our licenses and keep those up, and the continuing legal, education if our state requires it. And there's a lot of other things. And that's where it comes in play of why you would want a lawyer instead of an advocate. But when it's just looking at the IEP and making sure things look good, then an advocate is fine. You don't necessarily need a lawyer.
Correct.
Yeah. So, but once it gets adversarial, I'm like, nope, you need a lawyer. And I'll tell people because I've done consultations and in Germany, but like, I'll tell people, like, in this situation, you really do need a lawyer. Like, yes, we could be an advocate for you 100%, but I see it going to due process, and the way his law is written, if you go to due process and win, you get attorney fees. Me as an advocate, you couldn't get my fees.
Right. Right. That is another reason. Correct.
So it's like knowing those little things. And, good advocates know when to step out and say, like, yeah, you need a lawyer now. Um, so if people want to get in touch with you, they're like, oh, I'm in New York, I need a prenup or I need a postnup. What's the best way for them to reach you?
So they could go to my blog, and there's lots of information there actually about prenups and postnups, which is lisazeiderman.com. So just like my name.com. Or they could email me at lz@m, like Mary, zw-law.com.
Got it. And we will definitely have those links below. Lisa,
Perfect.
thank you so much for coming on the show and sharing all your words of wisdom. I found this to be really helpful for even those of us that aren't considering divorce.
Thank you, Francis. I think so too. I think that it's a helpful conversation for people to start to think about.
Yeah. And thank you all for joining us on this episode of Stress Free IEP. We hope today's conversation gave you new tools, insights, or just a little more peace of mind as you support your neurodivergent child. Don't forget to subscribe so you never miss an episode. And if you found this episode helpful, please share it with someone in your village. Next week, we're going to have episode 151, where Alexis Mays Fields is going to talk about arts integration in special education. You can always learn more and connect with me at schefterlaw.com or follow along on social media. Until next time, remember, you do not have to do it all alone.